Yes, so the word ping is utilized in the communication field in different ways. Specifically for T-Mobile, when we utilize ping, it means that a communication occurred between two entities and distance was measured. So think about measuring the distance of lightning. Typically, you're taught as a kid in science class that you see a flash of lightning and then you count how many seconds until you hear the thunder. And in miles, that would be how far that lightning was from where you are, basically measuring how far sound will carry. And pinging works kind of in the same thought process. The tower sends a signal to the phone, and then the phone sends a signal back. However long it takes, known as latency, is basically a measurement of how far that phone is from that tower. And what it does is it sends a signal to multiple towers at one time, which would be triangulation. 3 towers communicate with a cell phone and measure how far that phone is from those towers to then provide a longitude and latitude with an error radius of where that phone is going to be.
So when a law enforcement entity requests, I think you said GPS locates or pings, how is that process, how does that process started in T-Mobile? Is it an internal process, or is it something where a live human being is actively monitoring it?
So with T-Mobile, once you send us the exigent paperwork, we set it up in our system. Essentially, you give us the phone number, we put it for that limited time frame. T-Mobile is 48 hours, and every 15 minutes, that requesting party will get an email directly to them. T-Mobile doesn't see it, mainly privacy concerns, but since they provide us legal documentation, by law, we have to respond and provide the information. So an email is automatically generated to that officer, providing a longitude and latitude, a link or a map of where that location is, an error radius, and it tells you the number that it was sent.
Drawing your attention to State's Exhibit 29A, could you look at those 4 pages?
Okay.
Looking at those 4 pages, are they consistent with records that T-Mobile, that process of sending the email containing the longitude and latitude and the, what did you call it, error rate or distance?
Yes, so error rate or uncertainty would be basically a longitude and latitude, and then we'll say the uncertainty is 5 meters. So from that longitude and latitude, 5 meters in any direction is basically where that phone could be.
Are those 4 pages sent from a T-Mobile email account?
Yes, they are.
Is that consistent with your review of these records in terms of what was requested by law enforcement?
Yes, the name or T-Mobile employee would be the person who set up the account. They actually don't get a copy of it. It's just sent and linked to their name for our internal tracking purposes to make sure that our customers' privacy is maintained in the event that either the employee or the officer was doing something they weren't supposed to.
Now, when you look at the exigence form that's contained at the beginning of the binder data, do you see email addresses in which the data was to be sent?
Yes.
What are those email addresses?
I have a B. Safris, S-A-F-R-I-S at wichita.gov, and then Joseph Daniff at kcpd.org.
So based on that, are the emails contained in 29A sent to those 2 email addresses?
Yes, sir.
So again, consistent with exigent form, protocol, and form?
Yes.
Judge, at this time, I'm going to move to admit State's Exhibit 29, and I would lay further foundation for 29A through Mr. Dana.
All right. Mr. Smart.
Just get Mr. Escher repeat that, I'm sorry.
Mr. sorry.
I'm sorry, I was having a different conversation with Mr. Ricker.
He's moving to admit 29, and he's going to provide further foundation for 29A to another witness for this hearing.
Judge, we object to 29% of our pre-trial motions and ask for standing objection.
We have a standing objection. Prior objections noted, overruled.
Judge, could we approach briefly?
Sure. I'm going to excuse the jury to the jury room for a few moments. I appreciate your cooperation and understanding of this matter. Mr. Smart, having informed me that Ms. Sesmas is currently having chest pains and feels she may be passing out. Ms. Doolittle, would you ask Ms. Sesmas if she thinks she needs medical attention? Okay. We can get an EMT call. You need to lie down, Ms. Sesmas?
Yes, I do.
Okay, deputies, if you can pick up back in my office area and have her lay down on the couch back in my office area, that's probably the most convenient, comfortable location, pending arrival of EMT. We'll be in recess, pending further development. Mr. Sierra, you can step down, sir.
Thank you, Your Honor.
Thank you very much. Be seated. As noted before we took our sudden recess, Ms. Sesmas was complaining of chest pains. Ms. Doolittle told us that Ms. Sesmas told her that she was feeling lightheaded. She was in obvious physical distress. She was taken back to my office area, laid down on a sofa. Within a few minutes, probably within the last 5 minutes, EMT arrived, a two-person team. They examined her. She's now being transported to St. Francis for further examination. Time frame is uncertain. Ultimate diagnosis or prognosis is uncertain. It's my intent at this time to inform the jury that there was a medical issue that needed to be addressed. It's being addressed, but I'm going to excuse the jury until 1 o'clock and have them come back. Counsel have any suggestions other than that?
I'll defer to counsel, but it seems to me a benign statement that there was a medical issue that needed to be addressed
Medical condition?
is sufficient. I don't know that we need to tell them even that it's Ms. Sesmas.
Her absence will be noted.
It will, but the less said the better is all
right.
offer.
Mr. Smart?
That sounds good.
All right. One other thing, at some point, I just want to bring this up before the jury came out. Mr. Sierra, the last witness, I think Mr. Roach had just offered 29 and 29A. 29A is subject to further foundation. I believe the record will reflect that 29 was admitted.
Correct, the 29A is still subject to further foundation.
Mr. Roach had no further questions for Mr. Sierra, and we're going to turn the questioning over to Mr. Roach. Excuse me, Mr. Smart, now I got me going.
I'll cover that with the jury, then I'll explain what's going on, and then we can excuse it until
Well, Mr. Sierra, I'll defer to Mr. Smart, but I think there are no further questions for Mr. Sierra. So,
Judge, I think the way that we can do this is I can't tell you that I have no questions for him, but at some point we will have the client back here with us in our presence at some point, I hope, and I will then be able to do that in their presence and say they have no questions. I think we can do that even without the witness present.
And we'll do that for the jury, then we'll do it again in the presence of your client. When she comes back, I'll be optimistic when she gets back.
That's not just.
All right. Care, bring the jury in, please. And have them go ahead and give them the clue to bring their possessions if they need to.
Okay, I can do that.
thank you for your patience and cooperation and understanding. We've got a couple of things to discuss with you. First, just as, well, for lack of a better term, bookkeeping, the last witness, Mr. Sierra, is from out of state, had a plane to catch. It's my understanding the state has no further questions for him anyway, is that correct?
That's correct, Your Honor.
It's my further understanding the defense had no questions in Mr. Sierra as well, is that correct?
Judge, my understanding is he has a plane to catch this afternoon, it's still available, but I don't have questions for him, so whether he's available or not, it doesn't matter.
All right.
I think once my client's back with us, I can say that again on the record,
All right.
and we'll deal with that.
All right. But on that basis, Mr. Sierra has been excused as a witness. We will have no further testimony from him. That was concluded. The medical condition has arisen, requiring some intervention. We're optimistic we'll be able to resume proceedings this afternoon. We'll just go ahead and give you a longer lunch break, a little earlier than normal, and ask that you all be back in the jury room by 1 o'clock. Hopefully we'll be able to start up at that time or shortly thereafter. Again, thank you for your cooperation and understanding. Again, the admonition I've had you under remains in effect. Don't discuss the case among yourselves with anybody else. Do no independent fact-finding or research. And if you happen to see any media account detailing anything about this case or this situation, don't pay any attention to it. If you start to see something, read something, or hear something about this case, as soon as you realize what it is, stop paying attention to that source, and then don't hear about that at your earliest convenience. With that, have a safe extended lunch, and we'll see you about 1 o'clock. Thank you. Now, ask everybody in the court to remain until we know the jury's off the floor. Counsel, anything further we need to talk about, place on the record before we're in recess?
No. Judge, I'm going to approach the court after we're done here for an order allowing me to go visit with Ms. Sesmas over at the hospital. She's in custody over there. I encountered some resistance and I can have some sort of court order.
All right, just fill one out, I'll give you one.
Thank you.
The deputies are going to call Garrett. Garrett will relay information to the attorneys as far as we know anything, as soon as we know anything. That we just show back at 1 o'clock and get some stats at that point in time to go from there, or develop an alternative plan. We'll be in recess. Thank you.